Welcome to our next part of the series where we're going to talk about how technology changes, but abuse doesn't. I'm here with my colleague, Jonathan Kurland.
Hi.
By this time, you probably know a little bit about Equitas, but we are a grant-funded organization that is meant to provide you with innovative, informed, and hopefully really practical strategies to improve your response to crimes like intimate partner violence, which is the focus of this series, but also crimes such as sexual assault, stalking, and human trafficking. We do that in many ways, including resources like this one. You should check out our website where we have articles, written resources, and a lot of public-facing webinars. We also conduct training events on all scales, including, single office trainings to national and even international trainings. Some of that is in person, and a lot of it is web-based these days. I think Jonathan will agree with me, one of our favorite parts of the job is doing 24/7, well, not 24/7, that's not the favorite part, but doing one-on-one consultations with prosecutors such as you guys who may have a case that you just really want to soundboard with someone, either because you want to think about what's my theme or theory of the case, or maybe you figured out, okay, this is a case I want to try doing something for the first time, maybe bringing in an expert, or you've got some tech evidence or digital evidence that you want to bring in, and we're always available to help you with that. Equitas is also really proud to be involved in several partnerships and initiatives where we're providing longer-term support to sites that are specifically addressing particular issues, such as the Sexual Assault Kit Initiative or the Enhanced Collaborative Model Human Trafficking Task Forces. We also do things for innovative prosecution solutions, which is really across the range of just individual offices that are trying to do something new and inventive, and we help support them. So follow us on any of these social media platforms, check out our websites, learn a little bit more about what we do, what resources we have available to you, but also you'll get up-to-date information about trainings and new resources that are important to the field. This particular project is supported by the Office on Violence Against Women. We're really proud to have their support, and we thank them for that. But what Jonathan and I talk about today doesn't necessarily reflect the views of the Department of Justice. Because we are always striving to bring you that innovative and informed work, we do a lot of that using our fair use doctrine, which means that we'll give acknowledgement and citations for others' work that we're sharing with you today and in all of our work. So let's get down to today's objectives, Jonathan. I'm hoping that we can have this conversation about how offenders misuse technology, and that's important framing that I'm doing there, misuse technology to perpetrate crimes of intimate partner violence and assert power control in the course of their relationships. We'll talk about the litigation of getting that digital evidence proving that misuse of technology into court. We're also going to provide you a plethora of sort of more advanced resources. So this will just be fairly basic, but hopefully give you a sense of what you should be looking for, how you can preserve it, and hopefully how you can present it in court. And then the flip side of that coin is while we're seeking all of that digital evidence, we know that the defense counsel may also be trying to do that for victims in our cases, and we want to make sure we protect their privacy within the constraints of our ethical responsibilities, and we'll talk about that as well. So I wanted to start off with this framing, and Jonathan, if you can help me here, which
Sure.
is that the problem really isn't the technology.
I absolutely agree with that as a statement. The technology, and I think this is true for so many dynamics of intimate partner violence, is usually it's a symptom or manifestation of something more underlying. And technology is the same thing. And a lot of the modes of technology we're going to be talking about today, when we get down to brass tacks, there's stuff that have legitimate and innocuous purposes, But how you talked about it when you're stating or listing our objectives for today's conversation, it's more about the misuse and and how offenders can then take this technology and appropriate it for their pattern of controlling victims and exerting power over victims, in much the same way that a lot of times the physical abuse, while it's the incident that we most respond to, at a fundamental level, it really is just symptomatic of the overall domestic violence cycle and dynamic that we have to be recognizing. And so that's what can make it really hard, is because technology is so pervasive in our society, even for people our age who can remember the 80s and 90s. Well, speaking for myself, not for you, Jon.
Thank you, Jonathan.
When maybe it wasn't so controlling. But it really is pervasive, and with that sort of just everywhere facet of technology, abusers can often figure out ways to facilitate it, to abuse and to harass and intimidate victims.
And I will acknowledge that we are the same age, and that even when I started prosecuting, this wasn't as pervasive. I really saw a steep incline throughout my career. And I look back and think about how we maybe spoke to victims early on, just asking them, well, just change your phone number, or like, don't get on Facebook. And now, nobody, I mean, only old people are on Facebook. And, but we also know that those strategies, well, they're not really even fair to victims. They may actually increase dangerousness, but victims should be allowed to have a full, and now especially with the pandemic, have a full sort of online life, because it can break isolation. It can be used to increase victim safety on the other side of things as well. So seeing the flip side of that coin, and not just being completely freaked out. I know you and I both train with our partner organization, Spark, which is the Stalking Prevention Awareness Resource Center. And they do a lot of trainings about, how different apps can be misused. And we definitely see audience members get a little bit scared listening to that content and making lists of things they're going to go home and like take their children off of. But and some things you do want to be cautious of. But I guess the point of this presentation is that it's really not technology that's the problem, and we need to figure out how to identify it as misuse and also allow victims to have, hopefully, without fear and without abuse and intimidation, be able to use technology for the proper purposes as well.
Jane, could you expand on that? Just the idea that advising the victim to just change your phone number or drop the social media platform or whatever. How can that make victims less safe, or what is the big risk for victim, even though that advice might be really well-intentioned, just in terms of victim offender dynamics? How can that put them more in danger?
Yeah, I'm going to channel Jen Landheis, the executive director of Spark, when she says, well, stalkers don't give up easily. So if they try to call you and you don't answer, or they try to call you and the number is wrong, somebody that has that stalking behavior isn't just going to be like, oops, oh, well, I guess I'll stop stalking them. But instead, they'll try to find other ways to get in contact with the victims. And that could escalate to in-person meeting at schools, at work, and even going to the home. So it can actually escalate contact if they're saying, oh, I can't, I'm not being able to see them on Facebook anymore. I can't do that. So we're sort of getting ahead of the ball here, but that's
right.
Really where tech safety and working with victim professionals that have that expertise of like how to keep you safe using technology, recognizing these dynamics. When we're talk about collaboration in a couple of minutes, that's going to be so key, because they can share with you, well, maybe you want to keep that Facebook open and you want to just you don't access it as the victim. You maybe want to have some other channel that you start speaking to your friends with, but not to close that one down. I think there's a lot of tips like that the victim service professionals that have this expertise are really good at working with victims on.
Thanks.
So misuse of technology, I kind of see it in these two different buckets, and it's going to be important for us to sort of sort that out when we're figuring, how do I enter this into evidence, right?
I agree with that. And I love that this is illustrated with a Venn diagram. And really, this is so widely applicable to so much analysis of intimate partner violence and intimate partner abusive dynamics as well. Because certainly I think physical violence can fit in a Venn diagram of criminal act, and also being a exercise by the offender of a power and control, part of an escalating exercise of power and control over a victim. But usually we're not capturing the escalation of that power control is usually going to be memorialized and identifiable through how the offender is utilizing technology for the victim. And usually that's not, I think, something we're always capturing in our investigations of domestic and intimate partner violence, because when we respond to it, it usually is at the 911 call. And while there are exceptions, most victims aren't calling 911 for tracking software or a lot of the technology facilitated abuse that we're going to be talking about in today's presentation. But by understanding and really sort of capturing the offender's utilization of technology, I think you're going to be able to identify the entire cycle of domestic violence rather than just the episodic response, as well as too, and we're going to get into specifics in well, I think the next slide actually, as well as that misuse of technology being an independent criminal act. Oh, wow, what a good segue. We timed it perfectly.
Yeah, so this is, I always say, okay, if you're looking at a domestic violence case, you've got to also know like all the tools that you have in your tool belt. And I know when I was lucky enough to work in a unit where we were really focused on our misdemeanor domestic violence cases, and therefore most of my cases involved one particular statute that I charged over and over again, which was our misdemeanor battery statute. Every once in a while, I get a stalking or a violation of protection order, but I don't think we thought more broadly about some of these other crimes that are a lot of times part and parcel of a domestic relationship that is abusive, but also are standalone crimes themselves and can start building. Not only can we hold the offender more accountable, but now we're showing like a much richer picture to a judge and a jury about what's really going on here.
And I think that's true, absolutely. The other thing I sort of think about when I look at this toolbox of crimes is how do a lot of crimes happen for a criminal? Is because there's opportunity. And with intimate partner dynamics, there's going to be so much identity for committing all these crimes. I think of identity theft and maybe an offender adopting the victim's profile on social media or their text messaging or however. How does the opportunity for that to develop? Well, one of the words in intimate partner dynamics is intimate, where the victim and offender are living close together, where they know one another, where they know one of the things like each other's social security number and birth date and what was the name of your first pet and the street you grew up on. And those sorts of things that can bypass maybe a lot of the security protections that we have in place to keep us safe when we're using technology and different sorts of social media. Offenders have access to it by the very realization, by the very fact of they're in an intimate relationship, partnership with their victims. And so they have access to this information and the opportunity to commit these kinds of crimes that are here. A lot of these crimes that on some level are built on the trust that a victim might have in an offender or the control the offender has over the victim, and both.
Mm-hmm. And so I think of that, especially with the ID theft and the computer crimes, and just would maybe recommend folks go and look at your statutes when it goes to this regard, because they may be lower level criminal acts than you think. You think of computer crimes and you may think of some like very high tech hacking, but it could actually just be unauthorized access. So access to somebody's Facebook account beyond a consensual access that was given by the intimate partner. ID theft, there was a case where they charged, so it involved spoofing, where the offender was calling the victim using a spoofing app, which we can talk more about offline if anyone wants to get into the details. We'll put you in touch with Spark. But basically they could make it look like somebody else was calling the victim. So this offender had access to the victim's contacts. They had mutual friends, mutual family over the years of the intimate partner relationship. So knowing that the victim would not pick up the phone if it was an unknown number or if it was the offender's phone number, they actually had it look like, oh, this is your colleague calling or your boss. And the way that the ID theft in that state was written, each one of those spoofed calls was a charge of identity theft. And after 10 of those, all of a sudden misdemeanor land became felony level crime. So you've got to kind of know those tools, not just like, oh, ID theft, but go and look at your statute and really kind of figure out, okay, what does this require? And then the other plug I'd say is just we're seeing much more in the course of intimate partner relationships gone wrong, this idea of image exploitation, sometimes referred to as, the non-consensual distribution of intimate images, which took the place of what originally people were terming as revenge porn, just out of favor, but I could see why it rolled off the tongue a little bit easier than the alternative.
You're right.
And sometimes that goes into extortion and blackmail. So really kind of take a minute and look at all your different statutes and what's required.
Can I give a quick stalking plug?
Yes, please.
So often, so many jurisdictions, and there's a few that don't, but so many jurisdictions are going to have a stalking element of emotional distress or mental distress. The other thing is too, Jane gave a really great recitation of how these multiple incidents of technology facilitated crimes can build up. When they do build up, and you might have sometimes maybe courts or defense attorneys' reluctance to view them as one big episode, stalking can be a great charging device to sew these all together and to bring them all together. Stalking is also a great device is even when you're introduced to a domestic violence dynamic through that 911 call of physical abuse. There's probably also in the history, if you do some unpacking, going to be these technology facilitated crimes. And stalking can be a great device to then sew together this the physical abusive acts with the technology facilitated abusive acts too.
Yeah, we've got another part of this series that's really diving into how stalking can be such a great tool, not only for the digital crimes, but for any of your intimate partner violence crimes. So another plug for stalking, and our partners at Spark will love us for that. Always trying to gain favor. So when we talk about the power and control piece, these may or may not rise to the level of criminal acts. That's really kind of key, but we still want to be identifying and preserving evidence of and looking to introduce them. What types of things have you seen with your facilitated or your tech facilitated abusive relationships?
Well, I think the most common, and gosh knows with offenders, there can be ways a lot more creative than this, but the most common is I think of the victim returning and being compelled or coerced to hand the phone over so the text messages can be examined to make sure no one was, and it's usually a her in these circumstances, to make sure no one was texting her or to see who they were texting, that sort of thing. Tracking movements. I can remember it was actually a domestic violence homicide I had where we did some unpacking, and there was a surveillance website that the offender shopped on, and we found out that a tracker was put on the victim's car, where when she had left the residence 3 days before she was killed, she went to a hotel. He just showed up outside trying to find her. No one there could figure out how he learned it until after the search warrant, after she was killed or murdered. But that's one of the things too. But technology too, we're talking about sort of the monitoring of it also as well, but also restricting that access to victims. I've seen that, like talking to victims, oh, gee, how can we contact you? And almost having to arrange with victims really inventive and sort of customized ways to contact them because their access to technology is so monitored as well. So, and as well as I think the usual, like I've seen contracts that offenders have about what victims can and can't do over the computer, and having to provide their passwords and being almost infantilized in that way.
And this information, like, isn't necessarily readily identifiable. Like you said, if you get a 911 call because there's maybe this acute act of violence, and then we're focused on that, how do we then make sure we're also recognizing and asking the right questions to identify this type of abuse that's related to technology?
I think part of it is going to be conversations with our victims, because a lot of, I think, victims, especially in an escalating cycle of domestic violence, they become so acclimated to it, they might not even recognize it. And I dare say, this is my personal opinion, and from my experience, is I think it's very unusual for the intimate partner abusive dynamic to begin with acts of violence. That's usually at the tail end. Where that acclimation and escalation starts is with technology, with the social media accounts, with the cell phones, with computer and tablet access. So by the time we meet our victim in response to an acute episode of acute violence, the victim is probably like, just considers the technology abuse normal and doesn't even think about it. And so I think the ways we do find out about it is by knowing the kind of proactive, not leading, not suggestive questions, but proactive questions to ask the victim and talk with the victims about, like, tell us, do you have any social media accounts? What does he say? And I use he because that's generally the dynamic. I don't mean to say it's the exclusive dynamic, but it in terms of that. But does he access it all? Has he talked about it all? And just open up the conversation and see where it leads. And I would say when it does lead, or the victim maybe does have evidence on their account, try not to take their device or seize it, but take screenshots, because again, our victims are depending on their devices for lots of things. But also keep our antenna up. Oh, gee, are we developing probable cause to maybe seize the offender's devices and dig in a little more deeply?
Mm-hmm. When you were talking about those really intentional questions, that reminded me of the first part of this series where we went spoke by spoke through the power and control wheel. And you can use that power and control wheel to sort of develop questions to get to some of this less obvious forms of power and control. And I've recently seen, and anyone who's on here, I'll dig it up and share it with you, a power and control wheel that was developed for tech-related abuse specifically. And again, I can't remember exactly everything that was on it, but I bring it up because those types of tools can be very helpful when we're meeting with victims, and we want to make sure, are we covering all these questions? Because we know they're not necessarily going to be leading with it. And if we just ask, like, what else has he done? We're not going to get to it. And in fact, a lot of this, when I was working as a prosecutor, diligent as I was, a lot of this information came to me after the victim had worked with a victim service professional in some regard, whether it be tech safety planning, or just like having a more kind of broad conversation about what was going on in their lives, whereas I was like elements of the crime. And then it would come back to me and say, hey, did you want to share this as well with the prosecutor? Maybe you could, share this with their consent. And I always found like a lot of these little nuggets, which ended up being fantastic nuggets, because the monitoring of the odometer, I mean, you really know immediately like what that relationship looks like. Clear, that little fact gives you such a clear view into the relationship, but I maybe wouldn't get that originally. And I think law enforcement likewise should think about using, I don't want to say checklists, but those tools and those resources where they can help guide the kinds of questions that they're asking as well, since they usually do have that, first chance to speak with the victim right when something has happened. And sometimes we call that the golden hour, where victims are really, more open to disclosing the extent of the abuse.
But, and it also has me thinking too, appreciating that the discovery of the tech facilitated crimes, it really is a process, not an event too, and relying on that collaboration from victim service professionals. Because a lot of the victimization caused by tech facilitated crimes, there's going to be some embarrassment for a lot of victims attached with that. If the offender has maybe intimate images of the victim on their device or the victim's device, when the victim first meets the responding officer at the call of 911, tell us every way he's victimizing, the victim probably, oh, he has intimate pictures of me and I think he's going to distribute them. Sure, there might be a lot of victims that would disclose that right away, but there's probably a lot of victims that are going to be uncomfortable creating the risk that could be exposed or disseminated.
That's a great point on several levels. You point out some of these challenges in our conversation about why it's challenging to identify this, but also the fact that that threat might be post-arrest. So we can't stop having the conversation. We always have to ask. And I know another part of this series was about witness intimidation and the prevalence of that, and that sometimes it's more subtle, and we should be asking about tech facilitated intimidation, like, hey, if you keep going on with this court case, I have these pictures of you. I could see that. So even if we ask them at the beginning, it might not have happened yet either. So to have this as a continual conversation for many reasons, I think is highlighted. Go ahead.
So, well, here we are, purpose of admission and looking at this too. And how are we going to get, when we find this tech facilitated crime, and maybe we don't have enough or we didn't charge stalking, because if we charge stalking, we're going to be able to get a lot of this in pretty easily as evidence of the crime, because that's going to be part of our course of conduct. But what are the other purposes about why we want to get this tech facilitated evidence in? And I mean, obviously, if it directly is going to be supporting an element we charged, that's great. That's easy to prove. But maybe when we're charging that felonious assault, or even that simple assault where we have to prove that offender's mens rea, or overcome the idea that this was an accident or something that just got out of hand, or the offender was just framing it as self-defense, the tone and nature of this tech evidence and communications, electronic communications, might really help to shine a light on that as to whether that's accurate and whether or not the prosecution can still meet our burden of proof. That overlaps and dovetails, I know, with the 404B, other crimes, wrongs, or acts, because a lot of this tech evidence is going to show other wrongs or bad acts perpetrated by the offender. And the purpose we want to bring them in is not just to show what a bad person the offender is, but for one of those proper purposes under 404B1. I think I touched on nature of the relationship a little bit too, but when this tech evidence, what's great about it, especially because the credibility of our victims are going to be being attacked. I've never met a defense attorney yet that's going to stipulate to the credibility of my witnesses. I've been waiting for that. So that's always going to be an issue with our jury. And so when we have this tech evidence that can objectively, I would often say objectively, corroborate what our victims have disclosed, what they've reported, then that's critical, because that's always going to be an element for the case until our defense is willing to stipulate to the credibility.
Absolutely. So again, this is not going to be a deep dive, but I do love personally talking about tech evidence and digital evidence, and but it's constantly changing. Some of you may be working in jurisdictions that have your own separate protections on electronic evidence. For example, in California, a lot of things that other states could get with subpoenas, you may need to get search warrants. So really big caveat here about checking not only your local law, but the current state of the law when it comes to this area of protection, because we have this amount of digital evidence, how technology has affected our lives, how intrinsic it is into our lives, has just leaps and bounds happened in the last couple of decades. And I sometimes bring up the fact that the first Supreme Court case that talked about, could you get into somebody's cell phone? They made the analogy that a cell phone was really nothing more than a little black book which would have been like a little address book that you just keep in your pocket with people's phone numbers and addresses. And of course, case law, Riley really shaped it and came out and said, these cell phones are so much more than a little black book. They are so much information, so interconnected the information is, that it really can paint a picture of somebody's entire life. And so they need to have this really enhanced protection. That has continued to be the trend of the Supreme Court when it comes to location data. The latest case being talking about cell site location information, which our phones are sort of always collecting, and that we are not necessarily really knowingly allowing someone to have access to. So I would say just generally, and Jonathan, if you agree with me, I'd say if there's any content of communication, then we're going search warrant. That's really the biggest bright line that I know. Location now is sort of getting there. But things like subscriber information, transactional history, IP addresses, that type of information that doesn't have content of communication, we can still usually get through subpoenas. Again, check your local law. And then there's this middle area of court orders that still some types of location data you can get through court orders, including like tower dumps. And again, this could be, week-long training on all of this. So I think those are the big pieces to hit.
Well, I think diving deep really runs the risk of this going further than one course, and also the risk of it becoming dated by the time we finish this recording. I do want to note, and again, at the risk that this is maybe too deep a dive for a 101 level thing, I'm always kind of surprised that in the 2010s about subscriber and location data, although I think a lot of Supreme Court case law was anticipated, there really only was Jones and Carpenter, which is telling us one of two things. Maybe the Supreme Court's afraid to do it because it is such a messy area, or there's a lot coming down the pike in the next decade as we try to figure this out, but I'm not sure. But yeah, of course, Riley addresses a different aspect, more the privacy aspect. But in terms of what is protected and what isn't protected, there's really only two big Supreme Court cases, in my view, on it. And I would have thought there'd be more by now.
I think there's a lot bubbling up, Jonathan, as your second prediction there. There's probably some fear too, because it's constantly changing. But one of the other things I wanted to talk to you about on this slide was this is really resource intensive. Like it takes a lot, and a lot of the crimes we're talking about may be misdemeanors. So how do you get either buy-in for law enforcement, like please do all of this work for a misdemeanor at the end of the day, or how do we find other ways to build these cases that maybe aren't as resource intense?
Well, I think it goes a lot to how we triage intimate partner violence cases generally and figuring out a way to prioritize them. But I think the buy-in is by taking with the appreciation that a lot of times this evidence is going to be there. And under a lot of codes and under a lot of statutes, there's a likelihood of repetitive instances can then aggregate into a felony. Or especially for the type of domestic violence, intimate partner violence cases that require a lot of responses by law enforcement, and that always seem to be at high risk for attrition. By digging into this technology evidence, we're going to be making that conviction more likely. So those cases or that particular offender that seems to be commanding a lot of resources by virtue of attrition can be mitigated by building that really strong misdemeanor case, even when the felony option might not be forthcoming.
Mm-hmm. So yeah, I always think about it with sort of two places. We need to kind of do a little bit of buy-in work. I used to try to lighten the load and help folks, sort of write and review these orders and sort of do some cross training with law enforcement. That was really helpful. I think when law enforcement got a successful case and they got information that was like that aha moment, that can continue to build upon like why we do what we do, especially when then we've got a case that can stand by itself, maybe without a victim's participation, or with a victim that may be at that point of trial minimizing for lots of reasons. But I also think it's good. important for us to realize that not everything needs a search warrant or subpoena. Like if we have the victim's consent to take screenshots or screen recording of their phone, we can preserve evidence in a less resource intensive way as well. That may also have the benefit of safeguarding the victim's privacy. So there's sort of ways that we can do this a little bit less resource intense. So I'd also want to think about exploring that. Like you can, anyone on here, you can go to Facebook and you can download your own archive of Facebook. So, if that's the important thing, you may now only have the victim's side of it, but sometimes that's all you need. So think about really what kinds of evidence you need, and you may be able to mitigate some of the resource intensiveness of these cases.
The other thing to increase buy-in to, which I forgot to mention, but should address, is when we develop probable cause for an offender's devices, oftentimes, and we can examine that, there's going to be a lawful vantage point in which evidence of other crimes can be observed. And I know the definition of what is or isn't a lawful vantage point in electronic searching and seizing is one of the things that are being contested right now. So I offer it with that caveat, and something that might be subject to litigation. But look, people who perpetrate domestic violence, it's not often that they're going to have, moral bright lines that this will be the only type of crime I perpetrate. They might be deciding to do other things that once a victim gives us probable cause to search their devices, we can discover, or more crimes relating to that specific victim.
Mm-hmm, mm-hmm. So these are some resources, as we've sort of alluded. We're not giving you a deep dive into this, but a couple of things: search.org, great place to find law enforcement guides and online portals to almost any sort of digital evidence type venue you might. Everything from Facebook to Fitbit to Sony PlayStation to lots of other things that I have no idea what they are. The other one is that there is a listserv. If you have a prosecutor, you have to be a verified email address, but you can join the digital DA listserv. I'm a member. I am constantly appreciating the types of information and analysis and how people share things on that listserv. And then New York Prosecutors Training Institute and the King County Search Warrant Resource Center out of Seattle. Both of them have law enforcement only portals where you can download sample go-bys for search warrants, subpoenas, and everything you could pretty much think of. So those are all really fantastic resources if you find your work really getting into that more high-tech digital world. And you can share the latter two with your law enforcement partners as well.
I think the King County Act thing is publicly accessible. Like anyone can just grab it.
Really?
Even a law enforcement. I think when I last checked it months ago.
I could see that being the case. So now we have this stuff. We want to get it into evidence. And I think this is where we have to know this. We have to be able to talk about this simply because we have to educate the judges that may not be comfortable with this type of evidence. So sort of bringing it down, bringing it to the basics. And these are sort of the two basic pieces that I think we have to work with when entering this into evidence.
I can only speak from my perspective, but for an attorney my age, when this evidence first starting to come into play in cases, the novelty of it made it kind of intimidating as to how to get in, both for myself and also for the courts, as to how do we prove these things. Really though, and maybe younger lawyers and prosecutors don't have this challenge as for attorneys my age. Maybe you do, I don't know, but really the kinds of challenges we're talking about, how to get electronic evidence or electronic communications into evidence, it's the same kind of theoretical admissibility challenges you have with a typewritten letter. How do we prove its contents and how do we prove its authorship, or at least make a good colorable claim as to authorship? And that's really our first hurdle: authentication. Is this what we claimed it to be? Is this who is it by what we're purporting it to be from? Some jurisdictions have pretty broad admissibility standards. Just the testimony of a witness is enough to do it. Other jurisdictions are going to require a little bit more. But really, conceptually, when you're thinking about it, even if your evidence professor didn't change your textbook from the 1990s, the principles behind the typewritten letter and electronic communications are the same.
Mhm. And I do like to just remember, Matt, it is what it is claimed to be. It's a very low bar. There's some great case law that talks about it being a low bar. So, that's where I used to say, this is about the admissibility, not the weight, right? You can argue the weight. This is just like, am I getting it in front of the jury to have the jury even look at? And that's a pretty low bar. And usually, like you said, depends a little bit on what type of evidence it is. You may have a chain of custody issue. You may have a business records custodian, but a lot of times you're just going to have your victim say, this is a text message I received from the defendant. Now, the defense attorney can argue whatever they want, but that really, it should be enough for authentication with some caveats. And then the other one is, well, that text message is only relevant if it's actually connected to the defendant or to the defendant's device of some sort. So that relevancy is sometimes the bigger hurdle than the authentication. But I will tell you that if you as a prosecutor can't really understand that very core, and you've got a judge that's maybe not comfortable with digital evidence, and you've got a creative defense attorney, they can really make this very confusing. I often joke that I had a defense attorney I worked with. He was a previous cyber crimes prosecutor from our office. And he really was able to sort of get the judge to a point where the judge was like, maybe Mark Zuckerberg has to come here and testify. I don't know if I can bring this Facebook in unless Mark comes. I mean, I'm exaggerating, but it can get to that level. So it's, again, just always trying to remain sort of grounded in the basics. And I love, Jonathan, your analogy that it's a typewritten letter. And it's really not very much different than that. So what are you trying to admit? How are you going to authenticate it? And how are you going to link it to the offender? That's kind of my three pieces. And this kind of works with whatever you've got. So I'll give us an example. Okay, I've got before a battery happened, assault and battery, the victim receives a text message from intimate partner. Text message says, victim sends a text message. Text message says, hey, are you going to come home straight from work? And he's like, no, I'm going out with the guys. And she's like, don't forget rent is due. And the fight is about rent being due. So we want to admit these text messages, obviously, because they corroborate what the victim's going to be sharing at trial and disclosing about what preceded the act of violence. So what are you trying to admit in that case? Obviously the text messages, but like physically, what are you going to get the clerk to stamp? And there's a couple options, Jonathan, but what do you think are some, like?
Well, the couple options or avenues, and these are by no means exhaustive. But one, they could be screenshots of the text conversation from the victim's phone. The screenshots could be reduced to a printout, basically of the photograph, and asking, do you recognize the screenshot on this piece of paper? I do. How do you recognize it? And then they talk about it. It could be through a forensic examination of the phone that received the text messages or the phone that sent the text messages, which would be a high investment process to do it, but that's another way that they could do it. So then you would get the forensic examiner. You would have another witness to link the device to who controlled that device or utilize that device. Or you could do it through a combination of ways. Maybe you could have a victim talk about, oh, I received these messages. And maybe you could get certified business records from the victim's carrier and or the offender's carrier that's going to corroborate that while no content is in there, going to be able to corroborate that text messages were sent and received at or around the victim testified to sending or receiving them too. So those are, what are you trying to admit there? Or if you want to go the whole kit and caboodle, you could do all of the above as well.
Yeah, and what I love now is that you can easily screen record as well. So you can record and you could actually sort of scroll up. And that's helpful just because I think recordings are harder to tamper with, harder for the defense attorney to allege tampering. Also, a great way to say like you're not missing anything. You know, the screenshot, the argument might be, well, you're only giving me this 2 text messages, where you can screen record a little bit more. Otherwise, I think you're right. The other thing that might be helpful is going back into the victim's phone and making sure that the phone number matches, however that offender is saved in their phone. So there are lots of ways to put it together. But really authentication, if it's a screenshot, if it's the phone records, your victim can do a lot of that by saying, oh, this is how I have this person saved in my phone. I've never known anyone else to text me from this phone. We're going into linking the evidence to the offender as well. You could have those business records associated with the call logs or the text logs. You may have to do a chain of custody if it's a forensic examiner that has taken the phone and done the exam and come back with the report. And then those forensic examinations sometimes come in as expert testimony. I mean, we can really go further, but no matter what, these are the 3 things you're trying to figure out how you're going to do. What am I physically going to be admitting in court? How am I going to authenticate it by testimony, by records? And then how am I going to link it to the offender? How am I going to show that's the offender's phone number? That's the offender's social media account. Maybe it's a known nickname. Maybe it's the content of the communications that is actually linking it, because the communications, who else am I texting about rent other than the person that I'm living with and sharing my rental property with? So lots of ways to do it, but it usually is a combination of a lot of the ways.
Well, and when we're prepping our witnesses, or for investigators, when we're meeting our witnesses, when there's electronic communications, a lot of authenticating witnesses, they're able to think through these issues themselves, but probably they don't do it best when asked for the first time about it on the stand. And if when we're meeting with our witnesses, interviewing our witnesses, prepping our witnesses, ask, oh, well, how did you know it was from him? Oh, well, it came up in my phone as boyfriend, as husband, or whatever. Well, how do you know that was him? Well, I programmed his number into my phone. Well, how else do you know? Well, look at this text thread and all this other crap we've talked about. This is how I know it's from the same person. And a lot of witnesses, but usually not when caught off guard on stand. Jane, let me ask you too, sort of a different string or tangent. Like for recorded media, be it audio recording, video audio recording, my preference was always to reduce it to a physical specimen, not to date myself, but to a DVD-ROM or flash drive or something, and witness prep, let my witness view it, and then physically initial it. So then I can present them into the court and say, oh, do you recognize this CD or a flash drive or vinyl record? No, I never used a vinyl record with the initials.
It's
and
VHS.
they say, yes, I do.
I did enter a VHS into evidence, so it's not that old. This technology is changing very quickly, but yes, when you have to figure out some sort of way to physically have it in court, and if you're going to ask somebody to authenticate it in court, you really simplify the process by having them view it in advance, initial it, date it, and then have them talk about how they recognize their own signature and that I viewed this before. And when I viewed it, it was a fair and accurate representation of what happened. Yeah, that's a great way to do that. And I think a lot of folks are probably very comfortable doing that in the with 911 calls. If you're doing domestic violence cases, that was my first entree into doing this type of admission of evidence. So we talked a little bit about the safeguarding of victim privacy. Equitas has recorded a 90-minute webinar on ethical considerations regarding victim privacy and how to safeguard it within the bounds of discovery and due process in this digital context. So I really encourage you to reach out to that. Or I think it's just publicly facing on our website. But really the 2 sort of pillars are, what do you have to provide? Remembering you have to provide relevant material, exculpatory, Brady, Giglio. relevant and material is not everything. So I think that's where I say sometimes in our cases, we had these really like broad discovery, like you're never in trouble for turning it over. If it's, related to maybe a robbery that, people don't know each other, you're going to protect an address, but really you're not as concerned. With these cases, I really just would encourage folks to look through, especially if you've got voluminous records because you did maybe a forensic exam of your victim's phone, or you did do a search warrant for your victim's Facebook. You have these voluminous records, and be thoughtful within those rules and use the tools that you have to protect the victim. Redact, you can motions to quash, protective orders. Sometimes the phone is not within your care, custody, and control. You don't have to go get it on behalf of the defendant and seize the victim's phone. The victim has a right under the Bill of Rights and in many states and under federal law to be, immune from like harassment. And a lot of these discovery motions by defense counsel could be argued as being harassing of our victims. And we often see attrition from victims when these things are happening. And victims are not technically a party to our case, and they're not subject to discovery. So these are some of the ways that we can protect victims. Like I said, we did a 90-minute webinar. We work really closely with NCVLI, which is the National Center for Victims of Crime. And so I'd encourage you when you see this, because this is probably, one of the more consistent requests for help that we get from prosecutors, because I think it's just, defense counsel, asking for these things and us being really clear about what is discoverable, what does the defense have a right to under due process, and really what the victims have a right to protect. So keep up with technology and trends. That's us included. We're constantly, my greatest tool is looking at my younger cousins' cell phones and be like, what apps do you have on your phone? What do those do? Lots of resources to do that. Litigate the admissibility of digital evidence, protect victims' privacy when ethically appropriate, and work collaboratively so that we're identifying this evidence to begin with. So as I show you some more additional resources, including many of the webinars that I shared, I want to thank Jonathan for being here today and talking through some of these really emerging trends that we see when it comes to intimate partner violence cases.
Well, thank you, Jane. It was wonderful to participate and work on this. Good topics to talk about and very interesting.
Yeah, and hopefully this isn't outdated in the next 5 minutes.
Knock on wood.
Yeah, this is our information. That's my contact. You can always reach out, check out our website. We have office hours as well. I want to plug these. They're for prosecutors to sort of network and learn about emerging trends such as digital evidence. They're held the third Thursday of every month. You can register on our website and come when you can. It's from 2 to 4 in the afternoon. I know, Jonathan, you host a lot of these, and it's just a great opportunity for folks that are doing this really challenging work to have some support from peers across the country.
So ideally, when they work out in an idealized way, it's like a good lunchroom conversation when you're talking about cases, but with prosecutors from across the country.
Oh, I love that example. That was my favorite time. Thanks, everyone.